From the Library of Congress in Washington, D.C.
Good morning, everyone. Welcome to the first of two roundtable hearings on the topic of copyright law as it relates to software-enabled consumer products. I'm Cy Domley. I'm Deputy General Counsel of the Copyright Office, and I'll let my colleagues introduce themselves.
I'm Katie Rowland. I'm Senior Advisor to the Register.
I'm John Riley, Attorney Advisor.
I'm Michelle Cho, Ringer Fellow.
So I'll just do a quick intro, and then we can start with the first panel. So in October 2015, the Senate Judiciary Committee asked the Copyright Office to study copyright issues related to the spread of software in what it called everyday products. And in its letter, the committee observed that digital technologies have revolutionized our world, and that copyrighted software is now essential to the operation of our refrigerators, our cars, our farm equipment, our wireless phones, and virtually any other device you can think of. While crediting our intellectual property laws for these developments, the committee noted that questions are being asked about how consumers can lawfully use products that rely on software to function. The committee directed us to undertake a comprehensive review of the role of copyright in this area, while acknowledging that many of these issues may relate to areas outside of copyright law. So first of all, I'd like to thank the committee for this assignment and for its recognition of the office's longstanding interest and expertise in the intersection of copyright law and technology. Second, I'd like to thank all of the groups and individuals that submitted written comments in response to our notice of inquiry. We reviewed them all carefully, and they were very helpful in identifying the issues before us. And third, I'd like to thank all of you who agreed to participate in this roundtable to help us take a deeper dive into these issues. So some of you are veterans of our roundtables, so you know how this works. But for the others, if you want to jump in on the conversation, just turn your table tent upright, and we'll call on you, hopefully in some fair order. Just an explanation of the microphones. In order to speak, you have to press the button, the silver button, and the light will turn red when it's on. Only 4 people at once can have their lights, the microphones on. So after you're done talking, if you could just please turn your mic off, that would be great. Just a disclaimer that your remarks are being recorded and will be transcribed and made part of the public record and available on the Copyright Office website. And the panel obviously is being videotaped, and the video will be made available as well. So we've got 4 panels lined up today, 3 before lunch and 1 after lunch, and there'll be an opportunity for observer comments at the end, and I hope we'll have a productive conversation today. Our first panel is about a fairly general topic. It's the proper role of copyright in protecting software-enabled consumer products. And the goal of the panel is just to explore overarching issues like the need for copyright protection in embedded software, whether software in everyday products can be distinguished from other types of software, and the need for interoperability. But before I start off with the question, we'd appreciate it if each of you could introduce yourself and explain your affiliation for the record. So we'll start with you.
Hi, I'm Sean Bockert of Blank Rome, and I'm here representing Dorman Products, Inc., a supplier of new and remanufactured automotive parts.
Hi, I'm Christian Troncoso. I'm here representing BSA, the Software Alliance.
I'm John Bergmeyer, and I'm here for Public Knowledge.
Hi, Ben Gallant, representing the Entertainment Software Association, which represents computer and video game industry.
I'm Jonathan Band. I'm here on behalf of the Owners' Rights Initiative.
Keith Cooperschmidt, the CEO of the Copyright Alliance. We represent 15,000 organizations and individuals who copyright is very, very important to.
Aaron Lowe, I'm with the Auto Care Association. We represent manufacturers, distributors, retailers, and installers of automotive parts independent of the vehicle manufacturers.
Sorry, that's right. Steve Tepp, representing the Global Intellectual Property Center of the U.S. Chamber of Commerce.
Chris Moore, Software and Information Industry Association.
Jonathan Zook from ACT, the App Association.
Great. Well, thanks very much. So to start things off, the committee asked us to examine the specific issue of copyright issues related to software in what they called everyday products. And we understand the committee to have not asked us for a more comprehensive review of copyright and software generally. So with that understanding, I think that raises a key issue here, which is whether there are problems in the marketplace that are specific to software-enabled consumer devices, and if so, whether those problems can be solved without affecting copyright protection for software more generally. So to sort of open off, if anyone wants to comment on that issue, just tip your table tent up. Mr. Band.
So I think it's easy to distinguish software generally from software that is embedded in products, and I, it should be possible to craft special rules for the software embedded in products without necessarily implicating software generally. Where you're going to have definitional issues is like, what does it mean to be embedded or sort of software-enabled product? I mean, that becomes a bit of a definitional issue because sometimes you're talking about, you might be talking about firmware, or you might be, where really it is fixed, but you also might be talking about programs where devices where you have to download the programs, or the user has to install the software in some way to make it work. So that becomes a bit of a trickier issue. And then the other issue that you need to decide is sort of distinguish between everyday products or consumer products and other products. I'm not sure that's a helpful distinction. I think in 2016, where there's really no difference between business uses, consumer uses, private uses, and it's not very helpful to try to make that distinction will inevitably a very artificial one.
And in terms of problems that you see specifically with respect to, I mean, sort of the premises of the question was whether there are problems that are specific to consumer devices or whether the problems are really about software writ large.
Well, I would say that there are a specific set of issues that we know now. Certainly, and we'll be getting into it more in later panels, but the whole first sale issue, the ability to transfer products, the kinds of things that we've talked about in our comments, and I know some of the other people have talked about it, but the ability to sell devices, repair devices, and customized devices. I mean, those kinds of things that are sort of unique to when you have the software in the device. There are things you want to do with the device that you don't really care about the software. I mean, the software just happens to be there.
So I'm not sure exactly who's that. I think it was you, Mr. Troncoso. Yeah.
I'd like to just pick up on both the points that Jonathan raised, both in regards to sort of the distinction between consumer devices or everyday devices and devices that are not everyday, and then on the embedded software issue. I think that we agree on the first point with, I think, the vast majority of commenters that sort of distinguishing a device as an everyday device is not a particularly helpful designation, because it's just a category that's going to be constantly evolving. Technology, 10 years ago, we would never have imagined. I think that the phones in our pockets now have the computing power that sort of exceeds that which NASA used to land people on the moon in the 60s. So I don't think that's a helpful classification. And then on the embedded software classification, we don't think that that's particularly useful either, because we've had embedded software for decades, but I think the problems that people are identifying that gave rise to this study relate to the newer products, right? We're not talking about calculators or microwaves. We're talking about the newer classification of products that are sort of or internet connected at all times. The examples that came up a lot in folks' comments relate to things like Nest. And the issue there is not sort of the embedded software. It's that the software has a server sort of interaction, and that the software is more a service than sort of just mere embedded software. So the issues that people are concerned about, and rightly so, relate to how people's relationships with these devices that involve a continuous sort of interaction with servers. So I think sort of trying to narrow the scope of this inquiry merely to embedded software, I don't think is particularly helpful either.
Well, so can I ask about, so I mean, there's the one area where the law arguably draws a distinction is in the Computer Rental Amendments Act, where it says, computer program which is embodied in a machine, which cannot be copied. And if you look at the legislative history, and we had a follow-on study, what they were talking about were, I think, some of the examples that were in the Senate letter, which were automobiles, like those kinds of consumer devices, calculators, I think was mentioned, which you mentioned as well. Is that a viable distinction that we could use for if we were hypothetically to try to draw a distinction for embedded software? Is your point that that distinction that's in the law now really doesn't work to solve any of the problems that anyone has identified?
Well, I think my point is that, I'm not really sure what problem specifically it is that we're trying to address. And sort of merely, there's been a lot of people have focused a lot on the issue of licensing of software, and sort of, a lot of the software that is embedded on our consumer devices now is transferred by mechanism of a license as opposed to a sale. That, I think, is probably a little bit different than what happened, when microwaves first came onto the market in the 70s. So my point is that I think it's very hard to address these issues without disrupting the overall market for software writ large.
A lot of people have their tents up, and I'm not. Okay, Mr. Lowe. Thanks.
So, representing the automotive parts area, we've had a long history of experience in patent law with reverse engineering parts, remanufacturing parts. But the issue of copyright has arisen in a much greater amount because of the fact that software is on almost all automotive parts now that are being built into the parts by the vehicle manufacturer, which we think current copyright law, does provide the ability to do that, but the need for clarification, because there are a lot of issues when you're remanufacturing parts where software needs to be used. We look at software more as an automotive part or function rather than the actual, any creative thing. So like a windshield wiper might have a software embedded into it. It's taking the place of a mechanical part that would have been on there before. So we look at the whole issue of software as being, very close to being to an item that you could reverse engineer, copy, and use again to put on to make a copy of that part. And I think there's a lot of concern in our industry because we're no longer, the vehicle manufacturers seem to view this in a different light, and I think that's created a lot of maybe misconceptions and concerns in our industry, and also has generated lawsuits in our industry of our manufacturers. So we really think our industry needs a lot of clarification of some of these issues because they are creating problems for those that reverse engineer and build competitive parts and those who do service on vehicles.
So you mentioned lawsuits, and you also mentioned it in your written comments. I mean, could you explain exactly what those lawsuits involve, whether they involve? So I know that there's the Autel litigation going on, which really is not directly about the software. It's really about I think it's a data compilation case, basically. So could you just sort of explain what kind of litigation is going on?
We have representatives here that are involved in that. I can let them answer that question maybe more specifically. But they involve the use of software on an aftermarket part used on a car, on whether they had the ability to because they needed to use software to integrate with that vehicle, they had to copy it to do that. And I think that's specifically more of the issue. But we can let another representative talk about that more specifically. But that's the concern of being able to use software to make sure it's interoperable with a vehicle part. And sometimes you have to copy it to make sure it does that.
And is it your view? I mean, you mentioned at the beginning that you thought the current copyright doctrine could kind of address those, but that you wanted clarification.
I think there needs to be more clarification as how it relates to the aftermarket and replacement parts, reverse engineering, and also servicing of vehicles too.
Can I ask if you have a recommendation for this clarification?
I think we had it in our testimony that we submitted. I think just clarification about the use, and I think we'll get into a lot of these issues a little bit more closely when we delve deeper into it. But you know, the ability to copy the software, to use it as a if you're not if it's a non-copyrightable, if it's just a functional issue, interoperability, issues like that.
Mr. Zook? Okay, great.
Thanks, and thanks for having me here for this discussion. I guess I just want to start by saying that, you know, as a former software developer and now a representative of software developers, that software is the thing in a lot of ways, and I think it's easy to forget that the huge strides and innovations in computing have come predominantly in software, and that if you look at something like a big sensor, like a radio array, and you look at SETI, the only reason we're going to be able to filter the potential for, you know, extraterrestrial intelligence is because of software. You know, just imagine if you had that functionality on C-SPAN, it would be a lot easier to watch. But the So the innovations in CAT scans and a lot of machines come through software, and software is regularly updated regardless of what your definition is of embedded. I mean, it is a live and dynamic part of the software, and central to the incredible advance in software has been copyright protection. It's created incentives to invest, et cetera. And if you change them, you will change those incentives, I think. And so you will change artificially the way that people implement their technology in order to find ways to get protection for what they're doing, as opposed to actually creating more innovation in a space that's already highly innovative. I represent you know, app makers, and increasingly apps are finding their way into devices, whether it's scales or cars or refrigerators, et cetera. And that innovation, I think, is going to be critical. And I think that making the distinction between everyday use, I agree, is a very specious one. I mean, you know, very critical sensors are in you know, things like Apple Watches and Microsoft Band, et cetera, and that's going to be something somebody uses every day, and yet those are health related. So I think there's a real incentives problem, and I think ultimately you're going to start to see a problem around liability too. That you know, I've guaranteed to protect somebody's data in a particular way, and my software is going to be critical to doing that. I'm making assertions about the accuracy of a particular device, and software is going to be critical to making those assertions real or not. Compatibility and fragmentation of underlying technology. I mean, I'm a avid photographer, and the firmware of my camera is constantly being updated for compatibility with different lenses and things like that. And yet there are efforts to hack camera firmware, to add functionality in parallel. And if you do those things, you sort of do them at your own risk, because you're now out of the branch of the enhancements that are coming from the manufacturer for the different hardware that you want to use. And so then it raises questions about, you know, who do you call when your camera bricks up because you've fiddled with it. And I think that I think all of that is important to keep in mind as context for the discussion. Getting to specifics, I fail to see that there's been any real problem that's been identified here that's specific to software embedded in devices. It's all theoretical. It doesn't seem to be real. And I think that the copyright system has provided a set of kind of release valves already. There's exceptions built into things like the DMCA, et cetera, that are specifically designed for interoperability and study, security, et cetera, that have been used effectively. And to the extent to which there have been court cases around software being used and copyright being used sort of illegitimately, they've sort of fallen the way I think that people believe they should have. So it seems to me that it's a system that's working, and that there's no sign of a systemic problem, that instead there's a system that works, and we ought to be very cautious about changing it.
Thank you, Mr. Zook. I think we'll go down this line and then come back. How about that? So, Mr. Gallant.
Thank you, and it's a pleasure being back here at the Copyright Office and being part of this conversation. I want to first echo what Christian and Jonathan had said. I agree with their assessments of the current environment. And I think the broad point I want to make is that first, do no harm to the copyright protection system for software under the Copyright Act. That should be the ultimate goal of this particular study. And in terms of how do you differentiate, I think in terms of what ESA members care about, whether it be console manufacturers or handheld devices or even the new VR virtual reality units, every piece of software has a function, and you can't differentiate one kind of software versus another because they all interoperate, they all link together, they all make that device that makes all our consumers very, very happy. So can't be any line drawing because that would be regulatory chaos to say this kind of software is not protected or this kind of software should be treated differently. So the bottom line is whatever our members care about, and that is have an integrated unit that makes things go and makes the games go. That's how we should like to maintain it. Just keep the protections under the Act for software the way they are.
And what's your view of the line that's drawn in the Computer Rental Amendments Act? Is that, I mean, obviously that's about from very specific issue, but you know, there's both an exception for what they say computer program embodied in the machine that can't be copied, and then there's a separate one for video games that are also embodied and can't be copied. So,
right. No, I know exactly what you're talking about, but I can talk about that a little bit later. But right now, I'll keep to the statements I just made.
Okay. Mr. Bergmeyer?
Yeah, thank you. I think underlying the use of the phrase everyday products is this notion that, consumer products are different than, say, large-scale commercial, industrial, agricultural users, and that consumers have particular expectations and rights and protections that might not apply to a factory buying a bunch of software-controlled CNC machinery or something. And I think that's probably totally true. However, I don't think that copyright law is the right way to draw those distinctions between classes of users. You already have contract law already makes distinctions between sophisticated users and commercial users. I'm not an expert in this commercial law stuff, but I'm pretty sure the UCC or something makes note of those different classes. And particularly, from a consumer group perspective, something that concerns me is the notion of using licenses to disclaim liability for defects in products just because there's software and you can condition a software license on it where you couldn't with other ordinary consumer products. And I think consumer law already deals with things like that. A lot of states have rules which say that no matter how many times a manufacturer of a product tries to disclaim a warranty, it's ineffective. They have certain liabilities that are defined by law and there's no getting around them. Yet those protections typically wouldn't apply to a sophisticated commercial buyer of industrial machinery. And I think that's a totally appropriate distinction to draw. And it's not really necessary for copyright law to even be a part of that discussion of how do you protect consumers versus how do you not protect consumers. And my concern is the potential use of copyright law to try to whittle away some of those rights where software vendors typically disclaim all liability for any use whatsoever, and they say that their product is not fit for any purpose, and things like that, which maybe they might make sense in a pure software context, although I'm skeptical, but in a typical consumer product standpoint where you have software that is controlling power tools or a rice cooker, I'm very skeptical of things like that. But I don't think that it is copyright law that should really be part of the discussion in terms of those sorts of consumer protection.
And is it your view that that to the extent that there are licenses that do that the state laws that you mentioned would apply to those types of licenses?
I think it is unknown. Basically, I think questions like that would have to be litigated to the question of whether a disclaimer in a software license would have greater legal effect than a typical warranty disclaimer, which in some states might not have any legal effect. I simply don't know, and I think that we can either start thinking about these issues now, or we can just wait for there to be decades of litigation in a piecemeal fashion that might vary state by state, and I think that's the direction we're heading towards right now.
And is it your sense that Congress needs to do something to fix this, or is this something that Like, what is?
Well, in our comments, our position is that if you simply reject certain interpretations of copyright law that I think are mistaken, that have been adopted by some circuit courts, it's not necessary. However, certainly I would welcome congressional clarification of any of the policy points that we've identified, if it was at all feasible. But, you know, I think right now we're really not at the stage of proposing specific legislation so much as identifying the fault lines.
Okay, thanks. And we can delve into some of the licensing issues you mentioned in the next panel. Mr. Bacher, yeah.
So I guess to start, I'm sort of confused by this resistance to drawing lines, because it seems like we do that all the time in the law, and we do it in copyright law, and we do it in patent law, and we do it in trademark law, and, you know, we're relatively comfortable with that. And I guess maybe one thing that's coming up, and I don't think we dispute this, is that maybe it's not the embedded line that is where we draw the distinction, and maybe it's not the everyday products line where we draw the distinction. But I would posit that software that serves a primarily functional role in a product ought to be treated differently. And the reasoning there is, when you think about it in the context of patent, we have these things that serve functional roles, and there are specific carve-outs, like the doctrine of repair, and all sorts of, exemptions from the rights owner's exclusive rights. And we think that, several of those carve-outs and exemptions should also apply in the context of copyright.
So when you say a primarily functional role, I mean, all software at some level is functional. It's telling transistors to go to one or zero, and so I'm wondering. I just want to dig into that a little more. Do you mean
Sure,
a
it's a great
mechanical
question.
role? Or
yeah, that's a perfect question. So. Yes, I think so. Aaron gave the example of windshield wipers, right? So at one time you might have had a mechanism that decided how frequently a windshield wiper should swish, right? I'm sure there's a technical term for swishing, but I don't know it. And that would be a device that would be covered by patent, right? And auto part makers could come in and they could figure out, what's going on there, and they could figure out what their rights were in order to replace it under patent law. But now that mechanical unit has been replaced entirely with software. And so now we've sort of lost this aftermarket, and ultimately it's consumers who are struggling. And that's not to say that, we don't. I think that to sort of respond to some of that's not to say that we don't respect, copyright ownership and, the strong incentives that there are in coding and creating software. But it's to say that we also have competing, incentives and motivations, and that there are ancillary markets that we should also consider when making the law.
And is it your sense? I mean, there's sort of established case law about interoperability, and I know we're going to talk about the fair use. We have a fair use panel coming up third, I think. But just in general, is your sense that the current case law about allowing things like reverse engineering and intermediate copies for reverse engineering and enabling interoperability, do you think that case law is sort of sufficient to give your clients comfort, or is there more that needs to be done there?
No, I think we need more, and I don't think it's limited to interoperability. I think it would be replacement as well.
Okay, thank you. Mr. Cooperschmidt?
Thank you. So I actually last week was in San Francisco for the 512 section roundtables, and it's interesting if you look at the record and the description of all the problems that people are having with the DMCA notice and takedown process, and you compare that to the record here, it's just night and day. I mean, there's very little, if any, evidence of a problem. If you look through the examples and the written testimony, you'll see a lot of mays and coulds and mights, but you don't really see the pure facts. And to the extent there are pure, facts, examples, I think many of them don't have anything to do with the copyright law itself and have to do with other things. And I think there are other sessions where we'll delve into that more, although I'm happy to do that now as well. In terms of this line drawing for embedded software, it's one problem. In everyday consumer products, that's another problem. I think it's interesting that the one person here that suggested that, no, we should not have a problem with any line drawing, then draws a line that encompasses every single piece of software out there by calling it just, that any software that serves a functional role, which is, as you point out, the definition of sort of all software. So this line drawing is frankly very difficult, if not impossible, in this particular situation, both in terms of what embedded software means and what it means to be in an everyday consumer product. And not only is it difficult, but it's not helpful. We already hear complaints from the public and users that copyright law is too complex. And now we're hearing suggestions that not only should we should we make the copyright law more complex by creating a sort of a subcategory of software and treat that differently than other types of software. And then we don't treat it differently in all types of situations, just when it's in everyday consumer products, whatever that means. So this is just a hornet's nest of trying to draw that dividing line, which I think is a real problem. In terms of, you've been asking this question to others, so I'm going to preempt you and just try to answer this myself. You mentioned the rental right limitation and whether that's a viable distinction in this particular instance. But you also point out that Congress considered that issue when it codified this rental right limitation. It knew about the issue and decided to limit it to the rental right, not apply it across the board. So I think that's significant that Congress did consider this issue and decided to apply it in a particular fashion, in a particular manner. And then just lastly, with regard to the licensing issues, I'll pass on those because I'm also in session. I think it's 2. We'll take those up. So there were a host of issues that are raised in that context, but I'll wait on that.
Mr. Tapp.
Thanks very much. So one of the prior commenters made the statement that with regard to certain products, the software just happens to be there. And I don't think I could disagree any more fundamentally with that statement. Software is not just decoration. Software makes the products more efficient. They make it more safer. This is why software has accounted for 15% of all U.S. labor productivity gains from 2004 to 2012. And I think what this points to is really the fundamental policy question that underlies the entire conversation today, which is, on the one hand, we have a vibrant software industry. The United States unquestionably leads the world in this field. 3.2% of our entire GDP is from the software industry. Exports of software and related services have grown by 9 to 10% every year since 2006. We have something in our system, and I think it's beyond any serious question that copyright law is an important part of that system, that has generated a vibrant, productive industry that has helped the entire country innovate and move forward and into the modern era. So that's the one hand. On the other hand, as several of my co-panelists have pointed out, the concerns that are being raised are often hypothetical. There's some anecdotes. Very little of it is traceable actually to copyright law as the problem. So thus put, I think it's fairly clear that there's a very high threshold for demonstrating any need for, as we'll get to later in the day, a fairly drastic remedy of preempting contract terms. And I don't think that threshold has been met. And I'll just, coming back to the 117 rental issue that's come up a few times, I'll just add to what Keith said a moment ago, with which I agree, that amendment was actually designed to protect copyright in software. The rental of software was leading to piracy. People would rent the, back then, floppy disk, take it home, copy it, and then return the rental, the object of the rental. To the extent that at the time that amendment was passed, the ability to engage in that type of piracy in other types of objects where you didn't have the floppy disk at your disposal, I think is a significant part of why Congress made that distinction. It was not a distinction designed to denigrate the protection of software in other areas, but to enhance its protection in areas where it was the most vulnerable to piracy. It's an open question as to, going forward, whether piracy is becoming easier across the board, but I think it's important to remember that origin of that provision.
Well, since you raised piracy, I mean, I guess one question is, are there concerns about piracy in these sort of embedded software, in circumstances sort of where that exception to the consumer rental, the Computer Rental Amendments Act applies, where you have a Nest thermostat which has software in it? Ordinarily, it'd be pretty hard to copy the software off of that device. But you suggested maybe that's not the case anymore. So I don't know if you want to discuss that.
Well, I think we can all foresee that as it's easier and easier to have in ordinary consumers' hands the ability to access software that is embedded in a thermostat, as you posit, then piracy does, I think, become a greater concern.
But piracy, I mean, what would be the purpose of such piracy if you don't? I mean,
Well, if the software is the distinguishing characteristic of a product that gives it a competitive advantage, and I wanted to compete in that marketplace, then I would benefit from pirating that software into a competing product. Just one example.
So it's more competitors rather than sort of mass market piracy.
There's so much innovation in this space. I don't pretend to have the imagination necessary to envision every possible scenario. The fundamental case I'm making is that the laws we have now have generated an incredibly successful industry, that Congress has duly considered where exceptions are necessary and appropriate and has codified those into the statute, and that there is not anywhere near enough evidence to suggest a drastic remedy that's proposed. You asked a question about piracy going forward. I was pointing out that was Congress's motivation in the past in the Section 117 amendment. To the extent you're asking me going forward, are there potentially piracy concerns? I don't want to rule them out because I don't know. I can imagine a scenario where there could be.
Okay, thank you, Mr. Moore. And then we'll go over to, I think, Mr. Bergmeyer, then Mr. Band, and then back to you, Mr. Zook. Oh, sorry, and then we'll end up with you. Okay.
Thank you. I will try to be brief and not overly redundant. The first, I do think it's, from our perspective, important to look at this not from a framework of problems, but frankly a framework of overwhelming success. And that is, namely, that the application of copyright to software has been enormously successful in spurring innovation, and we've heard numbers and statistics about that, and we have some, we put some in our filing as well. Not only has it been true for software generally, but you're also seeing an enormous amount of investment in the Internet of Things in terms of venture capital, and we cited some of that stuff in our footnotes as well. And so I guess when we hear about these things, we say, okay, well, what's the problem? And frankly, for us, there isn't one, and there isn't one for a couple of reasons. The first is that the copyright law has enabled us to have both predictable and flexible business models. That licensing model has worked very well. It's worked very well not only for our member software companies, but we also see it potentially working well in the Internet of Things as software in that space becomes more and more like a service. And as consumers develop ongoing relationships, and in some cases very specific relationships, with their software providers for a variety of different kinds of data, it will make sense to maintain the integrity of those products, that the use of them be subject to particular terms. And there's no reason that people, if they don't want to be subject to those terms, or if they don't want to offer material subject to those terms, create a different business model. There is nothing preventing them from doing that. So we don't see any useful distinction or manageable distinction that can be drawn between software in consumer products and any other type of software. For us, that is a false premise. The second thing, I know it's more in the licensing area that I want to say, but I was confused by something that one of our colleagues mentioned before about the difference between the application of commercial law to particular transactions and when things go wrong. And I don't think there is a big difference between licensing and product liability. Product liability is a tort, and it's a tort under state law. So if something causes for example, a car to crash, the liability will sound in tort. It is not going to be governed by the terms of a license agreement, because that comes out of the Bloomfield Motors case from the first year of law school. I think that's a very different type of analysis. So trying to mix those kinds of horribles together. I mean, look, years ago when we were dealing with the aftermath of Pro CD and the world was going to collapse around us, we heard very similar claims about this, and it simply didn't happen. But this is one of the this was one of the areas that was mentioned back then, and I think the point is equally applicable today, is that where there would be product liability law that applied in the absence of privity, there isn't much that a software license can do to prevent that.
Okay, thank you. Mr. Bergmeyer, I think you were next.
Sure. So something that just relates to the functionality discussion a little bit earlier, and I'll use the windshield wiper example that keeps coming up because I just recently replaced the windshield wiper in my car. It's a very complicated mechanical contrivance. It's really difficult to get right. And I can imagine, yeah, it's replaced with a much simpler part that is just a microcontroller with some software, connected to some motors. And I think the question is, I bought an aftermarket windshield wiper armature replacement thing. Could I buy a replacement microcontroller with different software written by someone else? And I think when you have software that is of such a simple character, you end up with almost merger doctrine issues, where if someone else re-implemented software that did the exact same thing in terms of controlling the arms in a particular way, it very well might be the case that looking at the original software and someone's independently created software that does the same functions in terms of controlling motors, you might see substantial similarity. And yet at a certain point, you have to have an idea-expression dichotomy issue, because you can't copyright the only or the most efficient way to accomplish a task. Similarly, if I in a new programming language, say Go, I'm the first person to come up with the most efficient way to implement a particular sorting algorithm. It might be very creative of me, but that's not subject to copyright, because that is an idea-expression dichotomy question. So I think there are existing copyright law doctrines that have been around for a really long time that, at least when it comes to the very simple software that is just sort of replacing a mechanical part, could already apply to at least prevent the use of copyright to limit competition by people making other, competing products. And I think that is it's just something that people need to keep in mind when considering these things.
Okay, thank you. Mr. Band?
Some folks on the other side of the room have said repeatedly that there is no evidence. Now, simply saying that there is no evidence doesn't make all the evidence that's already been submitted in the record vanish. You have to actually look what's in the record. And so we've had Mr. Lowe submit, comments on behalf of thousands of auto repair folks who deal with this problem of replacement parts, exactly the kinds of things we're talking about here, and the competition in the aftermarket and diagnostic software, all of these related issues. They deal with that problem every day. I represent, within the Owners' Rights Initiative, are two trade associations representing computer resellers and independent repair providers, and they deal with this issue every single day. The Cisco frequently asked questions specifically talks about resell and restrictions that they place on resell of their servers because of the software, and they cite Werner v. Autodesk. It's in their frequently asked questions. It's not an occasionally asked question. It's a frequently asked question, which indicates that people who want to buy these materials frequently ask that question. HP has the same thing in their frequently asked questions. So this is, and the issue of independent, the issue of competition, the aftermarket has been an issue, an ongoing issue competitively in the computer industry from the beginning. And the independent software, independent maintenance and repair, it's been a big issue from the beginning. And 117 was amended precisely to deal with that. I mean, it's a constant struggle. Now, in the competitive struggle in Congress, typically the original equipment manufacturers have a lot more lobbying power than the independent repair folks. But that doesn't mean that the outcome that they are pushing for and have pushed for is necessarily, from a policy perspective, the optimal outcome. I mean, the point is that, again, this is an issue right now. We see it very much in the computer area and in the automotive area, and it's important for you all to be focusing on this now, because very soon it's going to be applying everywhere else.
So if I could just defend Congress, since I have representatives from Congress sitting in the audience. I mean, they did, just to push back on that point, they did, after MAI, they did issue an amendment to Section 117 to address that, specifically out of concern for the independent repair, to sort of facilitate independent repair, to deal with that particular issue. And so I think if there's evidence that there's that sort of problem happening today, I think, I imagine we would be, and Congress would be willing to examine that. But so that takes me to the next point, which is, I think it's one thing to say that there are issues, and there are obviously lots of difficult issues in copyright law, and determining whether something is fair use or not is a difficult issue. And so I'm just wondering whether you have sort of specific examples of either, threats of litigation or sort of areas where it's like clear that there's that's something that a independent repair person or someone who's making an aftermarket part wants to do is being prevented from doing because of current copyright law.
Well, the folks within ORI report that they are constantly being pushed around by the large computer manufacturers, that their and more importantly their customers, are being told not to get the services and not to buy used and replacement parts and so forth from my people, and that's what inspired our group to work with Congressman Farenthold in support of Yoda. I mean, that was a very specific bill that is responding to a specific problem that our members say that they encounter all the time. I don't think there's been a complaint filed that I'm aware of, but it is a constant issue.
And do you have? So I looked at the licenses that you cited and sort of looked up, for example, NetApp, and NetApp is an enterprise data storage company. Cisco, as far as I could tell, applies those sorts of restrictive license terms on its enterprise level devices. And what I couldn't find from your submission was an example of sort of a consumer level device, or even a small business level device, where that had these sorts of issues. And I assume that you would concede in the sort of business to business context, there's much more sort of a balance of bargaining power. And so I think one of our concerns is, again, to draw the distinction. I think that's appropriate, and the law does, as Mr. Bergmeyer said, draw a distinction between enforcing contracts between sort of between two businesses and between a business and a consumer, where it's a click-through or a contract of adhesion, if you will, right? So I think that, so I'm just curious whether you have examples of sort of consumer-level devices that have that type of problem.
Well, even when it says enterprise level, I mean, there are different kinds of enterprises, and you might have an enterprise of 20 people or 30 people. And so they might have a server for that level of enterprise, but it's still not. We're not talking about a 100,000 person company dealing with another 100,000 person company. And again, we see this, this is throughout the history of the computer industry, that you have very unequal bargaining power. And you really can't bargain with Cisco or HP or NetApp if you're even a small to medium-sized business. And some of the products that the ORI members deal with are also like, it could be equipment like this, like these speakers, and then these microphones or telephones. And so you might have a small office where you might have 10 telephones or 5 telephones. And again, you have very little, very unequal bargaining strength between the small business and the equipment manufacturer.
So I
Mr.
guess,
Bacher, yeah.
sorry, so my client, Dorman Products, is facing a very real lawsuit for, alleging copyright infringement, and they're, having to defend that. So this isn't sort of theoretical, and it's not hypothetical. It's very real. And, I can't go into all of the details in the case and sort of foreshadowing defenses, but the idea is, I think, this case...
Sorry, has a complaint been filed? Is it?
Yes, a complaint has been filed.
Okay. I think we'd be interested in seeing, if you have the docket site, we'd be interested in seeing.
I can send that
Yeah,
after.
that'd be great.
Sure. So, we obviously think we have very clear defenses, and we think that existing copyright law allows us to do what it is that we've been doing. But we think that this could be clearer, specifically focusing on, Section 117, which everyone is talking about. And I think when you open that up, I have the utmost respect for the drafters in Congress, but it's very difficult to read Section 117C to an auto mechanic and have them understand it in a clear way and have them understand how that applies to their business. And so when you have those difficulties, it does create chilling effects in innovation. And, it's not only Dorman who experiences this. I get phone calls from several clients who are calling and saying, hey, I have this idea, can I do this? And I have to say, well, here are the limitations and here are the things that you have to consider under copyright. And, a lot of them walk away and don't, end up creating whatever business it is that they had in mind. And I think keeping all this in mind, a lot of people are talking about the success of the software industry. I don't think anyone would dispute that, but I do think that there is some assumption there that the success of the software industry is based entirely on the strength of its protections under copyright, when historically a lot of the software protections were based under patent law. And patent law has very clear exceptions for things that you're allowed to do, like the doctrine of repair. And I think what we're positing is some of those exceptions should more clearly apply in the context of copyright law.
Okay. We're running short on time, so I'm just going to run down this side, and then we'll wrap up this panel. Mr. Cooper-Schmidt.
So I'll be brief. I mean, just to throw it back in Jonathan's lap here, I suppose, a little bit, is that, he said just because you say the problems don't exist doesn't mean they don't exist. Well, the opposite, just because you say there are problems doesn't mean there are problems. And especially, and I do...
I'll remember that the next time you guys submit that you need to change to the Copyright Act.
Okay, I'll watch for your tent to go up next time, too. But anyway, the problems that, or the issues that have been raised here, the concerns that have been raised here, a lot of them have very little, if anything, to do with copyright. With deference to Mr. Bachert? I don't recall reading the case. I would also love to take a look at the case, but it seems like it has not been adjudicated yet. So the courts may come to the, obviously to the right decision at the end of the day. It is worth mentioning that there are at least one, probably many, different voluntary agreements having to do with sort of a right of repair, at least in the automotive industry. So it is worth mentioning that there are groups that can come together and address these issues too, outside of Congress or other places.
Okay, thank you. I'm not sure. Mr. Lowe, were you? Yeah, okay, Mr. Lowe and then Mr. Tapp.
No. I wanted to clarify, first of all, the case is real, and we're familiar with the case that Mr. Bachert brought up, but there's every day when companies are looking at parts now, they're looking at software-enabled parts. Almost, every day they have to make a decision whether to reverse engineer, whether they can, innovate with the development of that part. And every day that decision is affected by copyright law. So there are very real effects that are going on because of this field and the need to clarify the right to repair in this software copyright area, because whether we all say software copyright is fine, there are no problems. Well, this is this area in automotive. When you purchased a car, you own that car, and you're able to modify it, to do work on that car, to repair it, and that's been a long-standing standard. But now with the software industry, software now implemented on almost every part and component on a car, that's now becoming more difficult and more questionable. And so what we're looking for is more clarification in that area to make sure that when you do want to work on a part, that there is a certain standard that we've gotten used to in the patent area is also applied in the copyright area.
Mr. Tapp.
Thank you. So, the copyright law already has clear jurisprudence and codification by Congress of reverse engineering for purposes of interoperability. So, and the Chamber's certainly not here to take issue with that. And the Copyright Office has famously issued some 1201 rulings that are in furtherance of that goal. So I think that ought not be lost in question of replacement parts. In terms of overall evidentiary issues, again, even the cases that have been brought up, the panel this morning has distinguished from copyright law. Respectfully, a frequently asked question is perhaps not a scientific designation of how often an issue may arise, to the extent that the concern is, oh my gosh, we have to think about copyright law when we do our business. Well, yes, people have legal property rights that ought not be infringed, particularly when there are means available under the statute to engage in repair, to engage in reverse engineering. And none of this justifies, as we'll get to later in the discussion, I suppose, this notion of wholesale preemption of contract terms, which is anathema to the free market system that copyright is designed to work within. And just coming back finally to the piracy question we asked earlier, the one point that occurred to me I should have made is that there is a clear and present issue with piracy, particularly in the area where the device that's run by software is the device that helps perform and display other forms of copyrighted works, whether they be music, movies, whatnot. Absolutely, in that context, you have the capacity for piracy of either the software and or the works that the device is designed to perform.
Mr. Zook?
Thanks. I'm not a lawyer, and so probably the least interested in reading the complaint. But as a software developer, what I've seen historically is there's always been a kind of tension between intellectual property and commoditization, and that tension's been interesting in a lot of ways. That the argument is made that eventual commoditization actually leads to innovation at some level. That now the thing you were protecting you don't have anymore, and you now have to re-innovate, et cetera. But there's also a historical precedent that sort of like commoditization too soon can undermine investment in innovation. But I think the key thing here, and this will come up over and over again, is that we should never confuse the two. Commoditization is not innovation. And very often innovation is happening here, commoditization is happening elsewhere. And so to look at it as commoditization as an innate good or as specifically as innovation, I think is a frightening characteristic for it. Because it's that innovation that I think that we need to make sure we're protecting and that copyright is put in place to protect. And be very cautious of things that sort of institutionalize commoditization too early in a product cycle.
Okay, thank you. Mr. Troncoso, do you want to have the last word?
Very brief.
Thank you. I think one of the important questions that Chairman Grassley and Senators Leahy asked in their letter that prompted this study is for this for you guys to look into what provisions of the Copyright Act sort of apply and how they apply now in this era where there's ubiquitous software in our consumer devices. And one of the things we've heard repeatedly here on this panel is that there seems to be some misunderstanding, at least among some folks, about how existing safeguards in the Copyright Act might actually be there and might be able to resolve some of the problems and some of the tensions that we're experiencing. So I think it would be helpful for you guys in this study to talk about that, talk about how, I know that 1201 is sort of a four-letter word in this panel, we're not supposed to talk about it, but how the triennial rulemaking is there to sort of provide sort of a release on the tensions that might build on sort of right to repair like issues, and also how fair use cases like Connectix and Sega v. Accolade apply to permit reverse engineering for purposes of interoperability.
So do you think it's appropriate for the public to look at our 1201 rulemakings as guidance with respect to questions about 117, fair use, that sort of thing?
That I'm not sure. I'm not sure if I'd be prepared to go there.
Okay.
But
Okay, just curious. All right, well, that wraps up our first panel. Thanks very much. What we'll do is we'll take if we can take a 10-minute break, that would get us back right back on schedule. So we'll be back here at 10:15 for session 2. Thanks.
This has been a presentation of the Library of Congress. Visit us at loc.gov.